It's Lisa from Been There, Got Out, and today we are welcoming back our friend, Canadian family law attorney Sean Valentine. Things have changed in his life. He's now the new dad of twin boys. There he is. Let me get you on here, Sean. 1 second. Yes. All right, good. Okay. Hi.
Hi, good afternoon.
And congratulations again, new dad, baby twin boys, right?
Yeah, can you see any bags under my eyes or not?
Can't see them. Mine are probably bigger than yours. I have years longer worth of eye bags with two kids, neither of whom ever slept very well.
Yeah, I'm getting that sense right now too. We're getting into the stage where everyone tells me the 6 to 8 week mark is when the crying and the whining get really bad, but even the 4 to 5 week is something. It's there.
3 weeks for me.
Wow,
3 weeks.
Oh my God, it's a lot. My wife has been incredible, so I've been really fortunate to be able to be a part of it, but also join in and great supports. But it's been awesome. I've been really happy to be a father. It's such an exciting time.
Yep, and 2 at once. I told you my dad and uncle are identical twins.
Yeah, that's exactly it. It's a buy one get one, but definitely not half off.
Right. Well, thank you so much for taking the time to come on. I know we only have half an hour, so you watch the clock because I'll have to turn around and check. All right. So I'm excited, and I know a lot of other people are really excited about this topic. Because it happens all the time. You know, a lot of our clients deal with it. A lot of people in our community have strong views on it, and that's sharing the story about a person's case while it's still active. So in particular, this topic came up because one of our clients has a gag order in her agreement. We have several people with gag orders, but her ex is really well known. And so she's been dealing with years of post-separation abuse. And she can't speak publicly. She can't post anything. I mean, he surveils her anyway. But all these years later, she's still furious because she feels like she needs to talk. Like she really wants to say what's on her mind. And she has this, there's this sense of injustice and there's a compulsion to tell her story. And what's harder is that Chris and I think that, like, we know her very well at this point, and she is hysterically funny, and we wish that she could get a career as a stand-up comedian, but there's no outlet. So first I was going to ask you, how common are gag orders in divorces and separations?
So they're interestingly, I can only speak obviously to what happens in my jurisdiction in Ontario, but right. We call them more publication bans in terms of gag orders, and they're not very frequent. Usually there are legislative ones that are mandatory, sometimes when there are sexual assault allegations, or in certain child protection cases when, a Children's Aid Society is stepping in and dealing with protection of the kids. Those kinds of publication bans are in order, but I don't see them too often in terms of the family law context, because the idea of the court process and the idea of the actual legitimacy of it is it's supposed to be an open court process. It's supposed to be a free flow of ideas, a free flow of information. The legitimacy of it is kind of that the courts need to be open so people can see it and so people can get the information that they need to through that process. So it's definitely few and far between, and it's an interesting thing that it's unfortunate that your client is going through that, because it must be difficult because they can't really release any information or talk to anybody. So they must feel very isolated when it comes to their process and their system and the situation that they're in.
Yeah. Okay. So, but as we know, like it's an uncommon where you are, and most people don't have a gag order, but a lot of people do use social media, especially TikTok and Instagram, to share their details of the case as they're going through it. So what's as an attorney, what's your opinion about that?
My real opinion is it's a bad idea. And
why? I mean, we have our opinions too, and we agree, but like, why do you think so?
Yes. Well, first of all, my opinion on social media in general is it shouldn't be a venting session. It should be obviously for information and it should be for connecting. There are so many people like you guys who you can talk to and be able to have a strategy session or at least be able to vent about the frustrations that are going on in your case. But there are a bunch of reasons why you don't want to post things on social media or other platforms and stuff. Number one, if you have a lawyer, you could be waiving solicitor-client privilege, which is a big deal. Like that is something that you don't realize, that if you're actually providing some type of information or you're talking about your case, you might be inadvertently now saying that, the information that I'm providing to my lawyer about this specific issue could not necessarily be protected by privilege. And that's a big deal because, that affects your strategy, that affects your conversations. And that's something that you really don't want to, you got to consider when you're doing it. Number two, you have a paper trail now. There's something out there showing exactly what you're saying in that moment, especially if it's out of the heat of anger or frustration. You're talking about your ex, or you're talking about something that has gone wrong. There is now proof that is not going anywhere, and it is easily accessible. It's identifiable. Your ex, even if they don't see it, friends, family, they might see it and they might take a screenshot of it. They might capture it. That's information right there that they could use against you. In general, it's really not a great idea to post things, especially while litigation or while your court process is going on, because everything is fluid and you really don't want to have to turn things on a head and have to defend yourself for some of the information that you're putting out there.
Yeah, I was going to say, what can happen in court? I mean, we've seen a couple of things, like penalties, fines, like future, like you're not allowed to say anything, but are there any things that you've noticed, like punishment or consequences for people that have posted about what's happening on social media?
Yeah, we get a lot of eye rolls. That's kind of the first step. The judges are like, come on, guys, like let's think rationally about this and think what you're doing is probably to the detriment, especially if there's kids involved, right? If you start blasting your ex or something like that on social media, it's not great for the kids' perspective. A judge can order you not to, what we call like basically a cease and desist order to stop posting things on social media, stop posting photos, stop doing things like that. If you were to continue to do that, you would actually be in contravention of an order, and then you could be held in contempt. And contempt can span a large magnitude of repercussions. It can be a fine, like you said. It could be imprisonment. It could be, that your application gets dismissed from the court if it gets really that far, or your answer, your reply to the person's application could get struck, and then that person can't defend against the person's application. So there are really large ramifications that come from doing some things like this and then not really listening to the court's instructions about stopping doing it. And I see people go for these kind of court orders all the time that they want to, and they're built into most separation agreements that you're not going to talk negatively about the opposing person. You're not going to talk negatively in front of your children about your ex-spouse, and there are real repercussions if you continue to do that. And then again, like we've been talking about, you have proof online. You can print it out and show it. It's not like it's unfortunately you just talking to somebody. You actually have tangible proof that you said something about it, and then that becomes an evidence in court against you.
Right. So there's no hearsay. It's right there. And then I was thinking too, when you said about the judge rolling his or her eyes, so it's like you're already starting off on the wrong foot because the judge is getting an impression of you and they're thinking something negative, and you definitely don't want to start off like that.
That's exactly it.
Yeah. And I was thinking too, like I'm thinking one person that we spoke to in particular, that we were telling her, like, what you're doing, you really need to get off social media with the things that she was saying. And she said, I can't because I use social media as my therapy. Mm-hmm. I don't have money for a therapist. This is the way that it makes me feel better. What would you say to someone like that?
That's actually really interesting, because I spoke to someone too who is a therapist or who deals with certain things like this, and she would that person would use her Twitter following to highlight some of the issues that she was having, but more from a therapeutic or a therapist hat on versus her actual personal perspective. But the problem is that sometimes the lines get blurred. And again, it might not be about you, but it could be the story that the other person spins here. And you might be using it for legitimate reasons and legitimate purposes, but then again, it's all about the narrative. It's all about the history of this file or the conflict between the two of you. And so when you might be using it for really beneficial purposes, you don't know what the other person's or the other lawyer is going to spin it on you. And that's the hardest part about it, is that you might have good faith to do it, but then ultimately we always say, right, is don't do something that's going to get you in trouble. So even if it has good intentions, try to avoid anything that's going to be used against you, because lawyers and other partners are good at spinning things, and they can make things that a mountain out of a molehill, unfortunately. And that's what we see a lot, especially with posts on social media.
Yeah, we often use the term about, like, don't give them anything they can sink their talons into.
Yeah.
Just give them nothing, like, just stay out of there. All right. Mm-hmm. What about, you mentioned something called surreptitious recording. Talk about that a little bit.
Absolutely. So that's obviously a big word, and all it just means is secret recordings that you've done, that the other person didn't consent to, didn't know about. Those I thought were a really good dovetail from social media posts and things like that, because the more and more I see, the more and more people are pulling out their smartphones, pressing record in their pocket, and recording conversations between ex-spouses without them really knowing it. And what's interesting about that is you think that that'll help you. You think like, oh, this is great. I'm going to catch my ex in the act of a heated argument or something that's really unfortunate like that maybe with the kids. But judges really don't like that. They really, really do not like recordings where the other person does not know they're being recorded. Most of the time, this evidence is thrown out. It's not even considered. It just makes you look bad. It makes you look like you're doing things to incite some type of conflict by having it in your pocket and stuff like that. If the person knows you're recording them and knows that this is the situation and they are acting in this kind of manner, yeah, I think it carries more weight in that sense. But the more and more I see people in the family law court, especially people who are self-represented, they think that hiding a camera phone in their pocket and recording all these interactions are going to be this gold mine of evidence that the judge is going to take and look at. And in my experience, a lot of judges will, again, do that same eye roll, really admonish them and say, this is not appropriate. You should not be doing this without, more so from just a privacy perspective, that's not permitted. But B, it really does not, it doesn't encourage resolution. It doesn't encourage collaboration. And by doing that and then just bringing out these, the recordings is just asking for the other person to do the same thing. And then you're just constantly going to be in a battle of one up each other with these private recordings. And then your legal bills go up, your evidence gets filed, goes up. Everything becomes such a much more complicated process. And really, at the end of the day, I very rarely see that it's what we call the prejudicial value of that outweighs the probative value. The actual value to the case is not significant comparatively to what the actual prejudice to that person would be.
Oh, that's so important, because that comes up all the time, especially the first time that we talk to someone. They're like, I've got all this stuff. I have all these recordings. And I'm so glad that you noted that, because I think it's a harsh Canadian instead of a New York reality check, but it's good to know. And here, different states have recording where, like, it's a one-party or two-party state where, like, it's allowed and it's not allowed. But I think it's important what you say about how if you do it, whether or not it's permitted in the state, it still looks a certain way to the judge. And there's that prejudice that, like, why are you doing it? And that we know that the etiquette of the court encourages resolution, or they try, or they expect resolution, they expect collaboration. To go in there with something that's really just going to escalate the conflict probably also makes you look bad. So
it makes it look, yeah.
Thanks for noting that.
And I agree with you. Obviously, consult with your local bar administration in terms of the rules of evidence and different things like that. And it's not necessarily that the that the recordings would be rejected from a evidentiary perspective in Ontario. It's more so that the value of those recordings is significantly less. The weight attached to them really, probably in most places, is a lot less than what you think. You think you might have this gold mine of information, but I think it's a lot less valuable than you might necessarily think. You want tangible and hard evidence. You want things to prove things like, you know, a third-party assessor talking about parenting, or you want other witnesses to come in and talk about their interactions of what they saw between the two of you and things like that too. These snippets of recordings that you might only play for 5 minutes at a time, it doesn't really
or less
true indication of, yeah, or a couple of seconds.
Yeah, that's what I'm thinking. 5 minutes is a long time. Yeah. All right. Somebody asked a question. What about back to the social media thing? What about private Facebook groups? You know, a lot of those groups, there is a digital footprint. What do you think about that? Have you seen that stuff show up in court?
I haven't seen it show up in court so often. Obviously, it's all evidence. If you're going to write stuff in there and you're going to be writing with your profile name on there, if someone is able to get that and take it, there's no anonymity there. There's no privacy. You're still on Facebook's profile, and they're still on their server. Just because it's a quote unquote private group, it's still public access. There are still potentially thousands of people in that group that could take a snapshot of it and send it to your ex, or again, you can do a third-party request for disclosure and get the dialogue of what the group has been talking about. And so ultimately, at the end of the day, you're still opening yourself up to be attacked. Now, obviously, your ex needs to know that you're a part of that group, and they need to know where to find the information and different things like that. But really, these support groups, especially what you guys do, you know, these are probably some of the best groups you can talk to, because it's actually a conversation. It's a dialogue. It's not just venting on your social media and stuff like that. And we always encourage all of our clients, get the right resources, get the right tools involved. Don't just, you know, vent on social media. Really find the right people that are going to help you through this process.
Well, thank you for that. Yeah. Also, we never record our meetings, and we don't have any written footprint of anything. We make sure our people, we say you're not allowed to record, no screenshots, like nothing. Even if Chris holds up a book during a meeting to recommend and someone's, can I take a screenshot? It's like, no, you can't. So okay, here's another one. So when I said that we were going to be talking about this today, we had several people write in under the post and ask the things to ask you. And so someone said that she stayed off social media and she privately journaled through her high conflict divorce. And she feels like she now has a book that she really wants to share with people because she thinks that'll be helpful to others in their healing journey. What do you recommend about that? So her divorce is over. Yeah. Do you think that that's a safe thing to do, or do you think you should still watch it? It's over. Uh-oh. John, your connections, or my connection is like a little bit blurry.
Yeah, I don't know if it's my connection or if it's your connection, but it's we're past. So what I think I heard there was this person put a book together of her experiences. It was a journal, and now she wants to share it with other people.
Yes.
Well, I wouldn't necessarily say I'm the best person to talk to about that. There's probably privacy lawyers and different things that you might want to talk to in terms of legitimately releasing private information about things. From a family law perspective, I can't, I don't think that there's any legal ramifications of doing so, but there are probably certain issues in terms of releasing private information from a privacy perspective that, someone might want to talk to, or there may be ways to talk about pseudo-naming people or changing some of the circumstances a little bit to make it better. Or again, it could just be a person's personal reflection on their situation of what happened and then a recount of it. But those are the kind of questions that probably need to go to someone in a very different area of law than me, and making sure that they get the right information on that. But what we always say, I think it's great that if someone can share experiences with other people who are going through a similar circumstance, and they can offer them some type of refuge, I think that's really important, because I tell everybody that I talk to in terms of clients, you're not alone in this. And there really is, unfortunately, a lot of people going through this process and through at different stages, but you have to understand that there are supports out there to talk to, and you got to remember that you are not alone.
Yeah, definitely. Okay, so then we got some other questions from people about, again, when the case is over, someone's ex's family accused her of slandering them on Facebook, which she never did. And she also had put a book out. So they didn't have a problem with the book, it sounds like, because I think she used a pseudonym. But have you heard of situations like that where after a case is over, the ex or the family still goes after somebody involved in it?
Yeah, I've heard it on both sides. During, obviously, that people want to talk about slander, defamation, libel, all those kind of things. Or people who maybe are still vindictive and angry afterwards can go and deal with it that way. The civil system permits someone to go and make any type of allegations that they want in terms of a civil wrongdoing, whether it's slander or defamation or whatever it is. But if the person can defend the case and they can prove that there wasn't really anything there to prove their case, then ultimately they're just allegations and they're just being talked about. Unfortunately, again, I tell everybody, when I used to do civil work as well, anybody can sue anybody. Like that's unfortunately the reality of the situation. Whether it's going to be it's going to have merit, and whether it's going to be something that they end up being successful on is a totally different story. And there are court costs that can be awarded against somebody to avoid that situation. But you can't be scared about someone threatening to sue. You just got to know that you have the evidence to defend it.
Yeah, that's such a good point. And then now, just checking the time, one of my last questions, like we've avoided talking about the Depp Heard trial, but and I'm not going to give any opinions on that. But I'm thinking, as an attorney, what do you think that case will really have strong effects on the domestic violence community, without saying who's the victim and who's not? Like, should people be like really scared because of what's happened?
I don't think so. I do think that every case is its own narrative and its own process. And I think, the Heard Depp situation was just, I think, a very unique case that is going to be celebrated similar to like an O.J. Simpson trial. Like, it's going to be just something that is going to be a kind of notorious. And there's probably, I'm sure, Sony or somebody's already writing a screenwriter for a movie about it. But I think ultimately, at the end of the day, people have to be still mindful that domestic violence is a real situation, and that they shouldn't be concerned to raise those problems or those issues that they're having, and that hopefully the justice system prevails in the way that it should based on the situation. Now, will people maybe be a bit more concerned based on what happened in that case? It's possible, but you have to realize that case it's a standalone situation. Those are two very individual people. Those lawyers are two individual lawyers. Their case is not your case, and you have to remember that you still have to be heard, and you still need to bring these issues of coercive control and domestic violence up to your lawyers, and make sure that they're informed about it, and make sure that informs the narrative of your file if you're going to continue to go through the family process. Now, Heard and Depp really was much more about the criminal context first, and then a civil context about defamation and losing contracts and different things like that. I think that I'm hoping especially that the family law bar and the administration of justice in that the family law context will hopefully recognize that in a very different way than what they were trying to prove in terms of a civil wrong to get monetary damages for lost contracts and stuff like that. So I don't think that it's going to play out in the sense that that it's going to change the way we look at domestic violence in a family law context. But I do think that, you know, you got to be mindful that there's always going to be, you always have to have you always have to be confident to bring that information up and not feel like that it's going to be swept under the rug during your separation.
Yeah, and I'm so glad you said that, because that's comforting, because I think a lot of people are frightened that now they can't ever speak up. But it is a totally different situation from I think most of the real world. So glad you said that. Okay. And then lastly, I know you got to go, but any other words of wisdom or how people can find you, and just finish it off, Sean.
Yeah. Finish it off. Well, you can find me on Instagram at my personal page, Sean Corey 42. I work at Epstein and Associates now, and so you can find me there on the Epstein Associates website. But really, at the end of the day, we didn't even talk about pro se people or anything like that in terms of self-represented litigants and all of this, and that's really a passion of mine as well, to make sure that people such as yourself and such as many other people are really confident in court and can really stand the test of time when they're litigating through these really troubling times. But really, ultimately, I think that what you guys do is fantastic, and the services that you provide are awesome. So keep fighting the good fight, and I'm just happy to be along for the ride to give you guys your viewers some more information.
Oh, thanks so much, Sean. All right, so go back to your babies or work or whatever you have to do, and thanks so much for talking about this today. I'm excited. I know a lot of people are going to watch it.
It's my pleasure.
And
so
be
nice
helped by the content.
Yes, absolutely. Well, have a great one, and hopefully we'll do it again soon.
We will. Okay, see you later. Bye.
Bye.